Good morning, everyone, and welcome to the MHC IP and AI annual webinar. Today is World IP Day with a theme of IP and youth, so it's quite timely that we're having our webinar today, and you're very welcome. We will have Q&A at the end, and there is a Q&A function obviously in the Zoom, so please feel free to use that. So I'll be speaking a little bit about recent IP developments, and then Hazel McDwyer, another partner in MHC, will be talking about IP in the Metaverse. So starting off with a sort of a rundown of the cases that we've seen over the last year or so under various IP rights that we come across: trademarks, copyright, patents, and designs. Trademarks is the first one, and the Metaverse is probably the big explosion of IP trademark activity in particular this year, and Hazel will deal with that in a bit more detail. But just to say, obviously, we've seen in the news quite recently that obviously McDonald's and a few other brands have got quite actively involved in registering marks in the Metaverse, and Hazel will talk a little bit about that in her part of the talk. Just on the first case I want to deal with, and that is the monopoly decision, which we've seen from the General Court of the EU. And Hasbro, which owns the Monopoly board game, which is clearly in use for games, had registration for Monopoly for board games and the like, and every 5 years kept refiling. And the reason they did that was to avoid the costs and expense of having to prove use of their mark if that was challenged in a potential opposition or an infringement case. So it was a sort of a cost-saving exercise. Because a mark can be challenged for non-use and taken off the register if it hasn't been used for 5 years, and that's obviously to free up the register for defunct marks. That was held by the General Court to be actually bad faith, which shows an extension of that ground to refuse registration. So therefore, the subsequent registrations could no longer be made. Now, they could rely on the older ones, but certainly that activity of evergreening trademark applications wasn't permissible. Looking at a decision, this is an opposition by Chanel, which is the famous luxury goods brand. They had a registration in class 9, which included software. Huawei, the Chinese mobile company, sought to register the mark that you see on the left of the slide there. And what's interesting about this case is Chanel argues that they were confusingly similar, because if you rotated 90 degrees, the Huawei mark you see on the left of the slide, it would look extremely similar to the Chanel mark, which we're all familiar with on the right of the slide. And the General Court of the EU held that is actually impermissible. You have to compare the registration that you have with the application that's being made that you're opposing. You can't manipulate it, in other words, rotate it, for example, or add some other matter to it to facilitate your likelihood of confusion argument. So from that basis, the opposition did not succeed. Looking at a few cases in the food and beverage sector. Here we have a case from the UK and the Court of Appeal, where HelloFresh was quite a famous mark. There's a lot of advertising that went into it. And they opposed a rival's Halal Fresh, which you'll see on the right of the slide. Now, HelloFresh had used a strapline quite a lot of "Dinner is solved" and did a lot of advertising around that. You'll see on the Halal Fresh mark on the right that they have "Dinner is sorted" there underneath. So taking all of that into account, given the reputation of the HelloFresh mark and all the advertising they'd put into its mark and indeed the strapline, it was held that the mark on the right could be successfully opposed on the basis of free riding, which is effectively where you're taking unfair advantage of the reputation of another mark. You may not be confused as a consumer, but it does wink at the other mark, the famous mark, and therefore you can successfully oppose it on that ground. So obviously the lesson learned there was they probably went a little too close to the bone in equally being close to the mark, but also using a similar strapline. Another case in the sector is to do with Oatley, which is a sort of an oat-based milk, and Pure Oat, which they took exception to and obviously took an infringement type action. Here, what was interesting about the case, the UK decision in particular, is that the mark contains the word oat, which is very much descriptive based on what is in the product. And what the court decided was, when you take away or strip out the oat element, you're left with LY exclamation mark on the left, and then the pure and the Y at the end on the right. And they're very different. And those elements that don't contain oat are very different, and therefore there wasn't a likelihood of confusion or a similarity to lead to a likelihood of confusion. So that's quite a useful decision in showing that when certainly naming in the food and beverage sector in particular, you can obviously use a descriptive element there without necessarily falling foul of an infringement type action or an opposition. Finally, on to sort of the food and beverage topic, we have a whiskey decision, which I've dealt with before in the webinar, but this is Eagle Rare, which is the famous bourbon from Kentucky, and Liverpool Gin Company introduced American Eagle as a whiskey. And again, it was held that there was no sort of likelihood of confusion from the purposes of people being potentially confused, but there was an indirect infringement, and this is the Court of Appeal decision. It looked at a couple of factors in this particular space, in that distilleries would potentially have a stable of marks that were sort of similar, like Jack Daniels or Gentleman Jack. Again, were two different types of whiskies from that particular distillery. Here, given that Eagle was considered somewhat distinctive to whiskey-based products, it was considered by the Court of Appeal that there would be an infringement of sorts, in the sense that consumers would perceive American Eagle to be a variant of a whiskey coming from the same distillery as Eagle Rare, in this case Sazerac Brands, and therefore there was held to be an indirect infringement that succeeded. Looking at a few cases in the sort of automotive sector, here we have Volkswagen taking a case based on their 3D mark, which you see on the right of the slide. And this effectively is the shape of their famous camper van. And this would prevent anyone from producing a camper van in real life to that shape. And they have a trademark which lasts for infinity, I suppose. It's renewed every 10 years. And quite a distinct protection is provided for. They would have acquired distinctiveness through use and got a successful application. What this decision is sort of useful for in demonstrating is that you can use a 3D mark to oppose a logo, such as 2D mark, as you see on the left of the slide. Here in the logo, there is a depiction of that camper van that Volkswagen produce, and therefore they were able to use their trademark to prevent that registration going ahead based on a likelihood of confusion. Another case in the sort of space is Pirelli sought to register the tire tread you'll see on the left of the slide, and Yokohama Tyres effectively opposed that on the basis that there is an exclusion from trademark protection for shapes that lead to a technical result. And that is a policy decision to ensure that parties can't trademark things that are needed for function or results of a technical nature, because otherwise it's sort of hampering innovation and other competitors being able to sort of compete. Here at first instance, it was held that when you look at the registration on the left and you add the sort of the side of the tires and the rest of the threads, etc., it performed a technical result, i.e. traction on the road and indeed dispersing of water. However, subsequently, when it was appealed in the General Court and in the Court of Justice, it was held that you can't add elements to the mark. In other words, as you see it on the left of the slide, you can't add more of the tire to it, as you see, like let's say on the right-hand side of the slide, to bring about that technical result. As it stood as a trademark application, there wasn't a technical result achieved through that just swoosh you see there, and therefore it wasn't held to be excluded based on a technical result exception to shape marks being registered. And indeed, the Court of Justice was mindful that there was nothing that in registering the mark on the left would prevent competitors from indeed producing tires and threads. Then looking at designs, and I've one case on that, which again is sort of on the car theme, and this is a decision of the Court of Justice which effectively looks at unregistered community design rights. Now we have two rights. You can register a design, or you have an unregistered community design right which lasts for 3 years against copying, and that's quite useful where you don't want to go to the hassle, I suppose, or costs of registering your mark. You can still have a 3-year protection period based on somebody copying what you've done. So you have to show a proactive knowledge and indeed copying. Here, what the decision held was Ferrari had produced a drawing of their FXK version of their car, and a company had come along, Mansory Design, and in fact produced parts of that design so that people could use them on their existing Ferraris to make it look like that model. So in other words, a component part of a more complex product. We know from design law that that can be registered as a design. We didn't know for sure, at least, that it could be protected under the unregistered community design right. I mean, this is what the Court of Justice decision decided. So in other words, if you release a product and part of your product is visible during normal use, if somebody goes about and copies that part of the product that's visible during normal use, then you can get unregistered design protection and indeed take an infringement action. Obviously, parts that are not visible, such as what's under the bonnet in the Ferrari, wouldn't be protected in the same way because, it's, as I said, it's not visible. Then looking at copyright. So I have a few decisions there, one of which is the YouTube decision, and this deals with liability of online providers. We were familiar enough with the YouTube platform, which allows users to put up various videos. And this is under the old sort of law. It has developed, I'll get onto that in a moment. But effectively, there is an exception where you're not liable for what you host on your site if you're not proactively monitoring and you're not aware of what users put up on it. And this decision, again, slightly older law now, but to the extent a case is taken under it, provides what is probably a slightly positive slant for the platform provider. In other words, it's not enough that the platform provider could know that there may be some infringing use going on their platform. In other words, it's probably a little bit inevitable that it's happening. If they're not aware specifically of it, and if they're not taking proactive steps to encourage it, to sort of monitor, to proactively put it up, or indeed set up a site for the very purpose of infringing, then they're going to be able to rely on the exception, and they must take down content that's specifically brought to their attention. The law, as I said, has moved on. In particular, we've had a copyright directive, which we've transposed into Irish law at the end of last year. And this did a couple of significant things. It did some minor things, such as allowing for copyright exceptions for text and data mining, and sort of fair remuneration for authors and performers where they might have not got a great deal initially. I won't look at that in any particular detail. But what we have is this Article 17 of that directive, which changed the landscape for online content service providers in particular. So instead of having a situation where what you don't know is going on your platform, you're not liable for unless it's brought to your attention, there is more of a proactive obligation on those platforms to come about with licensing arrangement with content providers, be it through collecting agencies or whatever, to have licenses for content to go up, even though it may be users that are putting it up, and effectively that type of thing is remunerated to the content owners, notwithstanding that the customers or the users of the platform may be doing it. There is a provision for an out-of-court redress scheme through the Mediation Act on that. Another interesting development is the introduction to Irish law of a press publisher's right, and this is where newspaper sites, etc., that pull together content and take an effort and time and expense in pulling together newspaper articles. This is dealing with news aggregator sites, which used to just pull the content and put it up on an aggregator system. That now can be remunerated, or indeed there is a right of the press publisher to get remuneration for that. And again, mediation can be sort of a redress to that. There are certain exceptions around merely providing a hyperlink won't be enough for private sort of use. Another copyright case seen at the Court of Justice effectively just expands or certainly confirms an extension of the scope of protection or of a defense to copyright infringement. And this is simply where you need, as a licensee of a computer program, to decompile it, to correct errors, to make sure it works with other systems that you may have. Those acts would in fact be copyright infringement and something that your license mightn't permit you to do. But we now have a directive which now has been interpreted by the Court of Justice that says you can, as a licensee, decompile the program to correct errors and the like, to allow interoperability and indeed for it to function this way. So it's a useful sort of defense that's been clarified by the Court of Justice. And then finally, we have a decision around Tunein, which you may be familiar with. If you use the Alexa app, for example, it'll put through some radio stations, but there were 70,000 music stations that could be listened to through the app. And what it did was it basically went to the website of the music station itself and then streamed it through on the app, but you wouldn't see that interaction, very much behind the scenes. Some of the rights holders, such as Warner and Sony Music, took exception to that in the UK because there wasn't rights for certain of the stations to be played in the UK and their music to be played in that way. What's interesting about this case is that it's one of the first cases post-Brexit where the court, and in this case the Court of Appeal, looked at the statute book in the UK, which is very much derived from a directive of the EU when it was a member of the EU. And here the Court of Appeal held it should look at and follow Court of Justice decisions around what is a communication to the public, because there hadn't been post-Brexit amendment to the legislation. And indeed, the Court of Justice had very much a lot of experience in dealing with that very particular issue. There are a lot of cases on it. So it's an interesting decision in showing that whilst the UK is now going it alone in IP laws, although a lot of their laws are derived from directives when it was a member, it will probably still, to quite a degree, follow Court of Justice decisions in quite a significant way. And finally, dealing with patents, two cases here, one of which is to do with Novartis and Eli Lilly, is a case currently going before the courts. And that is a patent infringement and revocation action in respect of a pharmaceutical patent. And here, the decision of TUMI that I'm dealing with is a recent decision around a modular trial, which is a concept you can bring about in any case. It doesn't have to be an IP case. But here, Eli Lilly, as the defendant, wanted to and brought an application before the commercial court to have the trial, so to speak, split up into two modules. The first module would be the infringement and invalidity of the patent issues. And secondly, they wanted the second module to deal with a competition counterclaim and the final reliefs in the case. Now, this had the practical effect of delaying the proceedings quite significantly. That is because we have an automatic right of appeal to the Court of Appeal here. So any decision, be it interlocutory or indeed on module 1, could be appealed to the Court of Appeal before you kick into module 2. And again, with module 2 being appealed, we were talking about quite a significant period of time being delayed as a result. So it was suggested by Novartis in defending that application that it was a tactical play. And there was a prejudice to Novartis in trying to split the trial up in that way. It sounded great on paper, suggesting to the court that there would be a lot of court time saved because some of the issues in module 1 may actually mean that module 2, to a degree, wouldn't need to be heard. But that was going to come with a price, i.e. that Novartis would not manage to get final relief in the case before patent expiry, and therefore the modular trial, as attractive as it may be to court time, potentially wasn't ordered. Another case, and I'll finish up on this one in particular, is an AI application in the UK, and the courts looked at this. It was basically an AI genome, which was emulating a sort of a biological genome, and it's just how it worked in the computer. And this was refused patent protection, and the court agreed with that on the basis that the AI was just a sort of a theoretical thing that was happening in the computer. There was no physical effect on how the computer operated or some sort of transformation as to something happening in the real world. I'll talk about that more in a moment. But I suppose the takeaway and the lesson from this case is effectively that for an AI type patent to be granted, there must be something beyond the mere theory. And I'll get onto that in more detail. Which sort of brings me on to sort of the AI and IP protections part of the talk. And so maybe Hazel, you can sort of start us off with a potential poll question.
Thanks, Jerry. So we're starting off with a, well, I think we're going to wait the first poll question. So should Irish and EU copyright or patent law be amended so that an author or inventor could be redefined to include AI? So if everyone would like to put in their answers, yes or no, then we'll give our poll responses at the end.
We'll also shortly discuss the law in that area so you can see where the courts have held.
So I think we might almost be there with the poll question. We might just push on then with the next part of this session, which is going to cover AI and IP. So Jerry, could you tell us how do IP rights protect AI-related creations?
Yeah, that's a good question. And effectively, we have a few potential IP rights that could apply. At the end of the day, AI is pretty much software. It's a computer, which is obviously doing something. And the front runner on IP protection for software effectively would be copyright. That's what the legislature has decided. There's a specific exclusion for patents, there's a specific exclusion for designs as they relate to computer programs. So the difficulty, though, with copyright protecting software is that it protects the source code and the manuals around that. But we know that you can emulate what a computer does through different source code. And so this is the bugbear of sort of computer software protection. You can only protect your source code being copied, and you can't protect the ideas of your computer program necessarily being copied or emulated. The ideas could be protected through patents. The difficulty, though, and I'll talk about patents in a bit more detail, with that is that you have to disclose what's going on. And for example, in your patent application, if the real nuts and bolts of the AI is the algorithm, if that's the sort of the sexy bit, that's really sort of beneficial. How does the Google search engine work, or whatever the case may be, that has to be disclosed in your patent application to be valid, and therefore, to get your monopoly for the 20 years. And you may not want to do that, which leads into potentially trade secrets being something that could protect that to the extent you can keep it secret through NDAs and the like. But we've certainly seen patents kick on in quite a significant way. Pure AI, as I mentioned, the computer program, can't be protected. It's specifically excluded from patent protection. And that is because the legislature says that. There's a European Patent Convention that says that. But equally, mathematical methods and performing mental acts and the like, those things are also excluded. So what you have to have is what we call applied AI. And that is where the computer is doing something of a physical or technical effect beyond what's going on inside the computer, if that makes sense. So some examples of that could be the robotic vacuum cleaner that goes around your floor and knows not to fall down the stairs, etc. Or indeed AI that sort of transforms text to speech, because obviously there's a physical effect in pronouncing the text. But for example, if you're in the metaverse, which is what you'll talk about shortly, Hazel, if you're dealing with a chess opponent in the metaverse, that AI machine that's playing you, that can't be patent protected, because again, that's just dealing with software and mental acts and the like. Or indeed in a due diligence, if you had software that looks at a suite of contracts and pulls out clauses such as a change of control clause or a choice of law clause, that, for example, won't be protected by a sort of a patent. As innovative as it may be, it's not something which is putting in fact a technical effect. The EPO has put in guidelines around this, but what we have seen is the number of these applications growing. There was 100 in 2010, there's 2,000 in 2020. They're not all necessarily successful for the reasons I talked about a moment ago. But again, this is to make sure that there isn't a block of innovation going forward, and that parties are able to sort of ensure that the public at large can use things that need to be used.
Absolutely. And I think moving on from that, obviously when we have a computer behind AI, how does the law recognize the ownership of computer-related inventions and creations?
Yeah, well, I suppose what's quite admirable is if you look back at our Copyright and Radar Rights Act of 2000, which is almost 20 years old, that envisaged computer-generated works. And effectively, that's where it's done a work, be it an article, be it a painting, is created by a computer that's not an individual. And it looked at ownership of that. And it basically said that it's not the computer, but the person who put the arrangements in place to create the work. So the person who was putting in the instructions of, I want you to create for me another Rembrandt, and here's a few Rembrandts I'm putting in, etc. That type of input, that person would own the copyright in the work, not the computer. It's probably similar to a degree in the patent space, because at the end of the day, we have a machine that's inventing something potentially. And there's been a number of cases around the world based on this Thaler litigation from Mr. Thaler, who had a Davos system in 2018, had created a couple of patents. I think one was for a food container and a flashlight. And essentially, Mr. Thaler put himself down as the owner of the patent because he owned the machine that invented it, but put down the AI machine as the inventor. So that inventor was cited as the AI machine on the application. And indeed, if the patent was granted. Now, there's been litigation sort of around the world on this. And recently enough, in the Court of Appeal in the UK, there was a 2-to-1 majority decision which held that as a statutory right, patents should not be granted to machines. They are human related rights, and therefore there is no right for a computer to be put down as the inventor. That was a 2-to-1 majority decision. There was a dissenting judgment which held that by Lord Justice Burst, which held that there should be allowing a computer to be an inventor. The US has held against the AI machine being the inventor in the same litigation in that jurisdiction. And indeed, very recently in Australia, the Australian Appeal Court overruled a first instance decision which allowed the AI to be the inventor of the patent. So they have shifted more consistent with the UK and the US position there in saying that AI machines cannot be inventors. So we can see how the sort of the law looks at it. It'll be interesting to see the poll questions in a moment, but that's certainly an evolving area which is certainly more in favor of the humans than the machines, so to speak.
Yes, I totally agree. And I have to say, with respect to the Thaler litigation, having been working in Australia last year when the initial federal court decision came out, it certainly caused a lot of waves in the IP community. So it's interesting that it's gone the same way as the UK and US. So moving on to our next question, AI relies heavily on data. How does a company protect the relevant output?
Yeah, well, that's interesting in the sense of it's all information and data at the end of the day. And copyright protects sort of written expression, as we know, but it doesn't really help here because it will only protect the database if the selection arrangement of the database is the author's own intellectual creation. That's not necessarily going to be the case in an AI produced system. The database right that we have, which does protect databases where there's an investment in the obtaining, verifying, and presenting of data, that's quite limited from Court of Justice case law. The Ryanair flight schedule or the Premier League football schedule can't be protected in that way because that's not the business they're in. They're in running flights or running matches, therefore their database can't be protected in that way. So it's quite limited. But what the Court of Justice held in Ryanair was that you can, through contractual terms, restrict the use of data that comes out. And that's probably the most relevant point here. The terms of use of the Ryanair website would stop or prevent people from using the flight schedules. And so it's a contractual issue. And here, similarly, you could put in place contractual provisions which would show who can use data that's generated, when, how, and for what purpose, etc. So that's probably the most relevant way of protecting that.
Yes, I agree. I think it really is important to have your contractual terms right to reflect what it is you need for AI. So all told, how would you go about best protecting creativity in the AI space?
Yeah, well, it's I suppose there's some challenges, as I've sort of mentioned, but it's probably a mosaic of a few things. I mean, one sort of analogy would be maybe TV format rights, which aren't themselves an IP right, but they are sort of a mosaic of different rights, such as trademarking the name. Let's say it's a show like The X Factor, you trademark the name. You might have some copyright around the catchphrases that might be used in it. You might have some designs in the set design, and you have contractual rights working to sort of protect that, and NDAs or to extent you need to, or whatever the case may be. It's probably quite similar here. You're going to have the software itself that'll be protected by copyright to a limited degree, perhaps some database rights, but equally you're going to have some contractual provisions there that are going to protect how the data may be used, or indeed licensing some rights that you have, IP rights that you may have in some of the AI related points.
Okay, fantastic. I think it's a good time to move on to our second web poll. So just coming off the back of the AI section. So I think the question should be coming up there. In your view, how well is your organization embracing AI? So just select one answer there, please. I think we've probably got everybody's answer at this stage.
Okay. Well, we might move on to your aspect of the talk then, Hazel, around the metaverse. And maybe we will start with the poll question here. The third poll question we have is in respect of, do you consider, or would you consider doing business relating to the metaverse in the next 2 years? It'd be interesting to see who has the metaverse on their radar.
And hopefully if people don't, they may do after today. So I think we can move on then. So today I'm going to discuss some branding issues in the metaverse. I'm going to cover off what is the metaverse and why is it important for IP, non-fungible tokens or NFTs. I'm also going to look at branding and trademark protection, as well as licensing issues and enforcement. So what is the metaverse? The word itself has been around for a long time. It was originally coined in the early 90s in a sci-fi model. It seems to mean something slightly different to different people. There's no fixed definition. I quite like the JP Morgan definition there, which relates to a seamless convergence of our physical and digital lives, creating a unified virtual community where we can work, play, relax, transact, and socialize. It sounds absolutely lovely. The closest thing at the moment that we really have is all of the various virtual worlds that exist. So the likes of our virtual world builders such as Roblox and Decentraland, as well as all of the gaming worlds, such as Fortnite. And then we also have all of the the use of Oculus, etc., that allows us to have that virtual reality experience. Most of them at the moment are centralized as to ownership. So the idea with the metaverse more generally would be that it would be decentralized, so that effectively you may have the same profile that could move from one world to the other, as opposed to having an individual profile in each world. And with the metaverse, NFTs will certainly have an impact here in relation to owning and transferring of assets. So why is it important for IP? Well, I think the main answer is it's worth a lot of money and it's growing exponentially. And with this has come a wealth of IP issues. As you'll see there up in the PowerPoint, the market opportunity is estimated at over $1 trillion in yearly revenues. We're already seeing a lot of success in the likes of virtual events such as concerts. Famously, Travis Scott performed virtually in the Fortnite game world to over 45 million people. A further 18 million people watched it on YouTube, and it has reportedly grossed over $20 million, so including merchandise sales. And you don't need to look too closely at it to see Travis Scott wearing a very large pair, his avatar wearing a large pair of Nike Air Jordan sneakers. So you can see the licensing opportunities there for brands. Last year, Sony Music announced its partnership with Roblox to create its virtual worlds for its performers to perform in. Similarly, Snoop Dogg created the Snoopverse in the Sandbox platform, and someone apparently paid over $450,000 for a plot of land in the Snoopverse a few months ago. So you can certainly see that people are certainly investing in it. So it really is a new frontier for branding and trademarks, and it's really important for businesses to make sure that their brands continue to evolve and that they get the protection that they need. So moving on to NFTs, or non-fungible tokens. These are digital-only pieces of data that are minted and can be bought or sold on the blockchain, which is akin to an online ledger. So they're different from fungible tokens. Fungible tokens are interchangeable themselves. So for instance, cryptocurrency will be a fungible token, or in the real world, physical cash would be a fungible token. Non-fungible tokens can relate to a specific physical asset or a digital asset. So it could be artwork, it could be an experience, it could even be real estate. So there have been a number of examples of NFTs. I'll have some here up on the slide. The Kings of Leon released an album last year as an NFT. So it came with it a number of perks. The NFT itself was only been sold for a limited period, but then could be traded as an asset in its own right. The Australian wine company Penfolds has had a few successful forays into NFTs. It launched an NFT project last year where it sold a single barrel of wine into 300 bottle NFTs of a particular vintage, the McGill's Cellar 3 2018. This vintage is not going to be sold at Penfolds cellar door, nor will it be sold at retail. So you could see how wine collectors will be very interested in this NFT. The first barrel alone sold in 12 seconds for $130,000. So clearly it's been quite a success. One NFT we've been seeing a lot of in the last few weeks has been Jack Dorsey's first tweet, which was originally sold for $2.9 million. The purchaser recently put it on the market with hopes of 48 million. I think the last I currently saw was a bid of about $14,000, so it's not quite at the level that he was looking for. The NBA has been very successful with an NFT trading platform called Top Shot. This allows fans to buy a moment, which is an officially licensed NBA or WNBA collectible video highlight. So they can range from the common ones where there might be 10,000 of these moments minted to there could just be, the legendary ones which might have 50 moments. So they very much vary in value. So from an IP perspective, an NFT is a combination of the digital asset itself and a digital certificate of ownership. So as a certificate of ownership, it's pretty well traceable along the blockchain, but as a digital asset itself, there have been a number of disputes that have arisen, which I will discuss in a few moments. But I'm just going to move on firstly to branding and trademark protection with the metaverse. Jerry mentioned earlier, McDonald's, certainly it got a lot of press recently when it filed a number of trademarks for virtual goods and services such as online concerts, online services selling virtual goods and also retail goods, and operating virtual restaurants. And when you look at the success of the likes of the virtual events such as concerts, you can certainly see those branding opportunities for a business such as McDonald's. And clearly it would have opportunities for sponsoring events within metaverse platforms. It could buy virtual properties close to events. Users could purchase digital McDonald's merchandise. And in fact, Coca-Cola was doing this a few months ago where people could buy Coca-Cola jackets as NFTs for their avatars. And then similarly, with companies such as McDonald's, the idea might be that you could then order your burgers or whatever online and in the metaverse, and then they will arrive to you in real life. So companies across the board are getting involved. We've got everything from financial services industry to celebrities such as Bronny James has got a number of NFTs registered. So trademark owners really need to sit back and think about their trademark protection and act quickly. It's particularly important in some jurisdictions where you might have a more specific specification. So for instance, in the US, where the USPTO will insist on very specific specifications for your trademarks, your existing trademarks may not be broad enough to cover the protection that you need. And so when you're looking at branding in the metaverse, some existing goods or services that you might want to look at could be Class 9 for non-fungible tokens, Class 35 retail store services featuring virtual goods, Class 41, there could be virtual concerts or other virtual entertainment, and also the minting and creation of the NFTs themselves in Class 42. So we always recommend that our clients undertake brand portfolio audits on a regular basis. But I think this is really an opportunity for brands to bring this to the top of their to-do list and start to really have a look at what you have protection for and how you need to expand it. And I think that's going to be really important when I look at some of the enforcement proceedings that have been on recently. First, we'll look at licensing and commercialization. So clearly there's massive scope for licensing and commercialization opportunities in the metaverse, and brand managers in most industries should certainly be considering this at the moment. Trademark licenses currently in place may not cover these sorts of technological advances or the potential for this commercialization. It's a good time to check them to see what they cover and whether they're too broad or too narrow. This is certainly an issue in the Miramax Quentin Tarantino case, which I will discuss in a few moments. A licensor should probably think about controlling the number of NFTs created. As I mentioned with the Top Shot NBA NFT marketplace, there are varying levels of NFTs that can be created for certain moments. So similarly, in order to keep them valuable, you want to keep a limited supply of them. So brand owners should really think about how they're going to do that and how they're going to limit the NFTs. How the royalty payments will be administered and accounting for is also important. With NFTs, you've got the ability to be able to trace the ongoing sale of NFTs along the blockchain. So there is a potential for royalties on resale of your works. Also, each marketplace generally has its own terms and conditions in relation to the sale of NFTs and the licensing of NFTs. So if you are looking to create or license some NFTs, it's worth reviewing those as well, just to make sure that you're getting the right terms that you need. It's also important in some cases the party who's actually minted the NFT may not own the underlying rights. So it is important to know exactly what rights are being transferred and what rights are being licensed. So with respect to enforcement, we're seeing a lot of increased activity in this space. With an expanded market, of course, there's increased potential for infringement. Nike has recently commenced proceedings in the US against Stockx, which is a streetwear resale marketplace. What Stockx does is it purchases your sneakers and then it creates NFTs with digital like for like. So you'll see there on the screen, it's got a number of different Nike NFTs. And then on the next screen, we'll see an example of what the NFT actually looks like and what you get for that NFT. So Nike has taken trademark infringement action and also claimed that dilution and unfair competition. Interestingly, Nike didn't actually have any trademarks filed at the time, so it doesn't actually have any registered trademarks now. It has filed trademarks for NFTs, but they're not registered at this point, while obviously it's got a large number of other trademarks. Stockx is claiming that its use of NFTs is no different than any other major e-commerce platform, such as your Amazons of the world, who are just selling, any goods or services. And they're also saying they're merely claim tickets, which allow you to go and claim the sneakers. But the thing with these NFTs is because they're being traded on an ongoing basis, some of them are actually worth a lot more than the actual physical asset. So it's going to be very interesting to see how this case plays out in the coming months. Hermes has also taken action recently against Meta Birkins. So Mason Rothschild is an artist who created a number of NFTs for what he called Meta Birkins. And you'll see the little NFTs there. They're little furry bags, which look like Birkins. Hermes has claimed trademark infringement of its Birkin trademarks, as well as infringement of its trade dress. Rothschild is claiming that basically he's not selling physical handbags, so he's not infringing any trademarks in this regard. And Hermes is arguing that there are, similar, it's a digital equivalent to a handbag. So again, this case is ongoing. I mentioned Miramax and Quentin Tarantino a little earlier. So what's happened here is Quentin Tarantino announced that he was going to be releasing some NFTs based on his original handwritten script from Pulp Fiction. Miramax is claiming breach of contract, trademark infringement, copyright infringement, and unfair competition. So there's a number of issues obviously to be considered here. One is whether the original contract, which bear in mind was the early 90s, whether that gave Miramax the right to mint the NFTs, or whether Tarantino's reservation of rights allowed him to actually do this. So it's going to be really interesting as to how this is interpreted. And looking at the contract in the proceedings, it certainly was quite broad. So it's going to be interesting to see how that will go. From a trademarks perspective, Miramax's trademarks do not actually cover NFTs. So they're relying on their more general trademarks that they have for Pulp Fiction and other Pulp Fiction related trademarks. Earlier this year, the footballer John Terry, who played for England and Chelsea, released a number of NFTs. These are with the 8 Kids Club. And so any of the football fans among you may recognize one of the images in the background there, which is the Premier League trophy, which is actually registered as a trademark in its own right. So the Football Association quickly came after John Terry, and he did take down those NFTs. So it really does show you how you really need to kind of be on top of these types of infringement where they are happening. So some key takeaways then in relation to the metaverse and branding is, number one, your protection. Review your portfolio and register trademarks to cover NFTs and metaverse developments, not least for your own extended protection, but also to stop any others who may want to try and file trademarks in those classes. Also look at your commercialization opportunities and further opportunities in the metaverse. Review your existing licenses and see if anything needs amending as a licensor or a licensee. And also from an enforcement perspective, you need to monitor your NFT marketplaces and your virtual worlds for potential infringement, and quickly seek the takedown of any potentially infringing content. But really, it's something that everyone's going to need to keep an eye on these cases as to the jurisprudence that's going to develop around this space. So now I'm going to pass you back to Jerry, who's going to quickly give you our last poll.
Thanks, Hazel. Yes. So the last question is around the metaverse again, and effectively it's to what extent your organization has implemented an IP strategy to protect your IP rights in the real world in the metaverse. It's a yes or no. And when anyone's had enough time to deal with that, we might start showing some results. So the first question was around the AI ownership of IP. And we'll see there that 59% of you thought that the machine should have some rights. And obviously we'll see how the case law progresses in that regard. The second poll was around how well organizations are embracing AI. And I think it's fair to say that about 60% are quite well and above, which is quite a positive thing. And obviously 10% were poorly there, but hopefully that'll improve. Okay, so next. Would you consider doing business in the metaverse in the next 2 years? That's quite close. I think the majority, albeit a small majority, is saying that they will not in the next 2 years, but possibly beyond 2 years. And then finally, the last poll we did there. Has your organization implemented a strategy around IP rights in the metaverse? And I think there's an overwhelming majority there that has said no. But again, it's a very burgeoning new area, which no doubt will sort of increase as time goes on. We did do a poll on LinkedIn in anticipation and in the run-up to this webinar, and we asked companies what they felt was their biggest IP challenge, whether it was patents, copyright, trademark or designs, and 44% had said patents was the biggest challenge for their company, which is probably not surprising given that it is quite a complex area. But interestingly enough, only 6% said trademarks, which I'm not sure is reflective of the fact they've never found themselves either pursuing or on the wrong end of a trademark dispute, or the trademarks are too easy to file. But that was an interesting sort of statistic. So maybe we can look at a couple of the questions in the time as permitted. To the extent we don't get to any particular question, where we can send a sort of a follow-up email with the answer. Hazel, I might start by asking you a question. And when it comes to NFTs, are there any specific issues we should be thinking about in letters of demand or cease and desist letters?
Thanks, Jerry. I think that's an interesting question. I think probably one of the issues that comes to mind is in our remedies that we seek from NFTs when there is an NFT that's potentially infringing. Obviously, I think probably the first issue is to make sure that you have the rights in the first place. So that's why it's important to get your trademark applications in. But I think when it comes to remedies, one issue with NFTs is that by definition, they can't really be destroyed or modified. And when we would normally send a letter of demand or commence proceedings, one of the remedies we might seek would be the destruction of the alleged infringing goods. And so when it comes to NFTs, we might want to just broaden that language a little bit. And it's again going to be interesting to see how the case law goes on this. But it could be worth including, that we might get it put beyond use. So, for instance, that they will be sent to a burner wallet or a burner address, so that effectively the NFT can't be untraded.
Thank you. There is a question that came in here, and I don't know if it's beyond our technical expertise, but it's how secure are NFTs when they're purchased, and what can you do to stop them from being stolen? That may be something for somebody else on the tech security side, but I don't know if you have any insights on that.
I think that potentially is probably somebody on the technical side of things, but I think the idea with NFTs is because they are on the blockchain and they are decentralized, that they should be more secure. But obviously, being a relatively burgeoning area of technology, of course, there are always ways that they could be compromised. But I think that the fact that they are decentralized should hopefully make them a bit more secure.
Okay, another question here. In respect of, it's for me, I think in respect of computer generated works that are produced by AI with very little, if any, human involvement, what's the issue around ownership? Well, as we saw in the 2000 Act, it deals with computer generated works, and the person who makes the arrangements would own it. And I suppose things have come on in such a way that AI itself may decide to generate something which is copyright protected, and there's very little human involvement, I suppose, is what the question envisages. That's something which there's no clear answer, I suppose. If you look at the most recent decision in the Taylor litigation, which was patents, albeit the appeal court there did look at various arguments around who could own AI inventions, which I think would have an analogy here in copyright. And that was looking at, well, is it the owner of the machine, which in that case is Mr. Taylor, or in this case it could be who owns the AI generating copyright work, or is it the developer of the software in the AI? Is it the person who puts in the source code, etc. So there are a few candidates, but I suppose unfortunately the law hasn't really decided what that is at this point. I suppose the factual issue for a court to decide is who is closest to the person that puts in place the arrangements to create the work. Okay, we'll do one more question, and as I said, if we don't get to a particular question, we're happy to send a follow-up email. There is a question here around the protection of data and protecting that contractually. Would you suggest putting specific additional clauses next to IP clauses of a contract dealing with data and derived data? Yeah, so as I sort of mentioned, to the extent we have IP protections and we're licensing that, that's fine. But to the extent that the data is not considered IP protected, it is important to put in those clauses. So you might be able to try and run a line that it's database right or it's copyright protected, but if that's not the case, then you should have specific separate clauses, albeit they could be besides the IP clauses. And they will deal, depending on the circumstances and the facts of what you're dealing with, though, they will deal with quite a number of things. In other words, which data somebody is permitted to use, how it can be used, sort of who can use it, when, for what purpose it's used, and sort of restrictions then on the use of the data, sort of limiting its use. But then also, how is it protected to ensure that it's not, for instance, dispensed to somebody else or misappropriated by somebody else. You might have some confidentiality restrictions around it as well. Okay, well, look, I think that's timely enough to possibly conclude the talk. A feedback survey will be presented at the end of the webinar, and please take the time to sort of fill it in. We're always interested to know of topics that you would like MHC to cover in a webinar, so please feel free to suggest a future topic, and we will circulate a copy of the slides to participants. And indeed, as I said, to the extent that there was a question or two we didn't get to, we will send a follow-up email and come back on that. So thank you very much.